Hi, everyone. Welcome back to the Wealth Preservation Podcast. I am virtually joined by my co-host, Josh Saunders, out in Texas. Josh, how are you?
Hey, Mark. How's it going today, man? We're super excited for this episode. We have joined by super attorney Brian Bradley. He's specializes in asset protection. And really, there's three neat things that we want you guys to take away from this podcast today. What is asset protection and how is it really defined, right? What does that mean? Because it means some things to a lot of different people, but Brian really breaks it down for what it's about. Second one is, how do you set up a good asset protection system? What is the process of that? And it has different layers, and how do you set those up? And then really lastly, who is it for? And Brian dives into what net worth person and what kind of jobs and businesses require that kind of protection. So we're excited to have that, and we hope you enjoy this episode. Let's dive into it.
Awesome. Welcome, Brian.
Hey, thanks, guys. Thanks, Josh and Mark, for having me back and getting this podcast back up. And I think it's going to be a great second part of a topic here. Especially if you're looking to make money, grow money, create freedom and financial flows and investments. And I hope that the concepts that we're going to break down today, help your listeners and help them keep what they got.
Absolutely. Yeah. So if you want to know kind of Brian's origin story, and Brian's kind of he speaks also on starting law firms and how to be lean and mean as a small law shop, so to speak. Go back and check out our episode before where we talk all about this. He tells we talk about marketing strategies and kind of what Brian did to succeed and how he wasn't an overnight success and he failed multiple times like we all have. But he's here kicking some serious rear end now, which is super awesome. So we're excited to have you here.
Well, thanks.
Yeah. So Brian, let's kind of hop in just real quick. You went to small law school in Southern California, did a whole bunch of trial attorney work, but how did you get interested into the asset protection realm, right? How did that kind of become, your niche or niche, so to speak?
Yeah, I just, over the years of having clients coming in and, after the fact, already being sued or, having their insurance and their insurance not covering them when they thought that they were.
Wait. I'm going to interrupt it. So you're telling me that insurance sometimes doesn't pay out? What?
What? There's insurance business and there's insurance law and defenses. You got to have insurance, and we can break that. We can just do that now if you want or later on. But you got to.
Let's do it later on. But yeah. I'm sorry. That's a sarcastic anecdote. So sorry.
No,
keep going.
It's great. It's not. It's great for the little things. It's not going to be there, in big matters.
Sure.
That's not what they make money by premiums. And that means taking your money, not paying out. And or people having revocable living trust. Like most people fall in the conclusion, like, oh, a trust is a trust. I have a trust, so I'm good to go. No, a revocable living trust not there to protect you. They can't do that. So then they come in, I'm being sued. Insurance isn't there. My revocable living trust, not going to do anything for me. What can you do for me? Well, at that point, it's really expensive, and there's not much. There's a very, very thin line that we can walk at that time.
Yeah.
So in order to help people be preventative. Before these lawsuits came in. And so, and I, being, obviously a trial lawyer and, a litigator and in court, the sad thing is, the legal system's broken, and it's not about justice any longer. We're just simply a sue happy nirvana now with more than, over 40 million lawsuits filed every year in the US. And I think they say something like 99% of all the lawsuits in the world are filed here in the U.S.
That's a great stat. Yeah, good job. Yeah,
We're number one.
Number one.
A lot changed over the last 40 years. And so I wanted to help clients get ahead of this. And, civil litigation is now a multi-billion with the B dollar industry. It's not, like I said, about righting wrongs anymore. So what we do is I just want to give clients peace of mind for clients and, while keeping in mind, like at the end of the day, the overall goal really is just lifestyle preservation. When you come in and say, hey, I want to protect my assets, what you're really saying is, hey, Brian, I want to preserve my lifestyle in a bad situation. Yep. So those systems, I look at it as a trial lawyer as what happens in court and how are these going to be upheld or not. And so we use very, very strong systems, but it's scalable, and we'll break that down. Like, I'm not going to say, hey, you're calling me and you're a newbie, pay for the Taj Mahal. That's stupid. That's financially stupid.
So real quick, Brian, that's where you're trying to talk, but let's define what asset protection is. Like, let's kind of give the big umbrella. And I know that, because that can be a lot of different things to a lot of different people, right?
Yeah. In its basic form, it's not traditional estate planning. It's modern estate planning. And what we're doing is placing a legal barrier between your assets and, a potential creditor before it's needed. That's it. is just a barrier, like a safe that you put your gold in, or your guns, or your other valuables. Anything of value you want to put behind that barrier and out of your own personal name, so it's not easily attached with a lien or attacked with a lawsuit or reached. And when done right, it levels the playing field from a completely out of control legal system.
Yeah, and you use the word system a lot. Like, there's no magic bullet, right? There's no like magic one size fits all. If you do this one thing, you're good, right? There's literally 100 different ways to crack that nut, right?
Yeah, there's tons of business entity. I mean, LLCs, LPs, family management partnerships, different types of trusts, high set trusts, foreign trusts, domestic trusts, bridge trusts. I mean, there's land trusts. There's a lot of different things. So if you're calling up to a firm and saying, hey, I want to protect my assets, and this is a big problem of a lot of firms, because they're trying to cast large nets and put everybody into one specific bubble because it's profitable and it's easy.
Sure.
Yep. If they're just going to say, like, the only thing that you need to do is create an LLC, the only thing you need to do is this, and it's not based on your needs, your situation, your assets, your finance, your liability, and they're not taking a whole detailed analysis of you, hang up the phone, because you're not your neighbor. Your neighbor's not you. Your businesses and liabilities in life is completely different. So what our job is, when it's done right, is look at the whole profile, find what legal tools and business entities and trusts we can use, and then depending on where you are on the sliding scale, what works.
Yep, perfect. And to touch on something else you said, like we've over the past 40 years become really, really sue happy,
Yeah.
And asset protection has shifted. Like, what was it that changed over the past like 30 or 40 years that made like maybe some things that used to work not work anymore?
Yeah, no, and I think that's a great question to start this, is because you have to understand like context to why it's important. And so like the legal system, like I said, has completely shifted over 40 years. And so, I said it's not about justice, but it's now about redistributing the wealth, your wealth and investors' wealth, from the haves to the have-nots. Now, for people who grew up like with a more old school mindset, where lawsuits really never were an issue, back about 40 years ago, you can get away with having things in your personal name. You can have things in a family trust. That was acceptable then, and you were able to get away with it. But over the last 40 years, the litigation landscape just completely changed. Things that, you asked about what changed that didn't happen are contingency fee lawyers. Up until, I think it was like 68, you couldn't have a law firm, hire a lawyer based off of a contingency fee, where you don't have to put any skin in the game. I'm going to file a lawsuit, and then me, the lawyer, I'm going to take 35 to 40 some odd percent of the winnings. That wasn't allowed back then. CPAs still can't get paid that way for a specific reason. What's your CPA going to do if they get paid off of results? Lie, cheat, and steal to cut your taxes down to get paid as much as possible. But we allow.
Wait. Are you saying that sometimes lawyers might lie? What? That is out of character. When you put a money incentive, people like all of a sudden moral compasses start getting a little wonky. That's weird.
It was when the Supreme Court, I understand lawyer advertising, like we're businesses, we need to advertise, but then that also opened up the floodgates to no longer being about good old Abe and justice and righting wrongs, but now we're just a business. It's pure profit line. If you don't make a profit, then our doors are going to close. So we hire marketing agencies, sales agencies, and use every sales tactic that everybody else has. And so it's no longer about, like I said, justice. It's just about a dollar amount. And so asset protection now is your modern best bet and attempt to level that playing field. And we're using all the different legal tools we have. And what this does is it makes it very hard for creditors to collect on you, and then this puts you back into like a position of strength. And when you go to a negotiating table, it gives you more leverage to force cases to settle, in your favor, or when we do really strong asset protection, which we'll talk about after the end of the scale, just to have them go away completely or settle for a penny on the dollar. That's really what asset protection is at the end of the day. Just hedging your bet against a crazy, out of control legal system and crazy judges.
Gotcha. So, kind of, Brian, what's the best way to break that down? About, do you break it down for cost? I mean, how come it's different for one person and not the same for another? Is it depends on the type of business they run, or just what they're trying to accomplish, or cost, or is it kind of that mesh, that kind of magic bubble of where all those three meet for that particular client?
It's where everything meets. Like for example, let's say you're a doctor and you're just coming out of residency, like you have a good paycheck, you have liability, maybe your malpractice coverage, potential lawsuit is going to be an over lawsuit. Like most doctors carry coverage for 1 million. If they work for a hospital, maybe that, malpractice isn't going to be a big issue for them. Then what are you investing? What are your investments in? Are you in real estate, heavily litigated area? Are you, whatever your investments in, are you buying strip malls? Are you, so we got to look at where your liability lies and then go from there. And so then you have inside versus outside liability. Inside liability meaning wherever you're being sued from. If it's an investment property, I have, liability that comes from inside that investment. If I'm a doctor, malpractice. What's happening outside liability? My life, me driving my car and hitting somebody, me giving my car to somebody, them drinking and driving and hitting somebody. So when asset protection is done right, you want to protect yourself from your inside liability plus your outside liability. And so we take a snapshot of your whole life. And some clients call in and they don't expect that type of deep conversation, but I can't recommend any type of system, whether it's just a basic LLC for a newbie, or like the bridge trust and all that's working, for our 1 million plus, clients, until I know where all your risk and liability comes from, what you own, how you own it. Is it mortgaged? How much is mortgaged? Because then I need to know, which we'll talk about, gross versus net. What are we protecting? Like I need to know the equity that you have, and how you have it, because then I either need to protect it or not.
Gotcha. Yep, that totally makes sense. So, kind of a good example of the inside-outside liability. I heard a lot of people say, oh, hey, I have an LLC, so I'm protected, right?
Yeah.
So talk about that difference again between that inside liability versus the outside, just in the context of an LLC and how that works.
Yeah. So let me just go over so big confusion generally is like charging orders. You're always like, okay, we're shopping for jurisdiction, Nevada, Delaware, Wyoming, where are we going to go? What are we going to do? So people really do have a lot of confusion on this, and where to set these LLCs up and what they're going to protect or not. So a lot of the time they're going to talk to their CPA, or they hear something on the internet and they're like, I'm just going to go do that because that's what I heard and what, I was told to do. Well, it really comes down to an issue of what are you holding? Like, what are we actually trying to protect? So let's say for, like example, it's a California real estate that you're holding, and you set up a Wyoming LLC because somebody on that, on the internet or your CPA told you, this is better, this is what you should go and do. And then you go and you bring it to California, and you hold a key piece of California real estate in this Wyoming LLC, and you're paying California franchise tax. And what you've done now is essentially converted your Wyoming LLC to a California LLC, because you're doing business in the state of California. And not only are you going to pay the franchise tax in California, but if you ever have liability, or a lawsuit in California, the judge in California or any other state is going to apply which state law? Like California. That's where you're getting sued from. Not Wyoming law. A judge in California or any other state doesn't care, that your LLC in Wyoming is registered in LLC, a Wyoming LLC.
I think, Brian, we should be a little more specific. The California judge could give a crap about Wyoming.
Yeah.
Like, literally. I could use strong words, but he could care friggin' less.
I'll break that legal versus practical authority. Like, we'll go there, and so people can understand some more of that. But they don't care. That's the state, and that's the state that the asset's in. That's where the lawsuit is going to be.
And now we lost Josh. Small tech glitch, but we're back on it. So, Brian, you were talking about the legal versus practical authority, and why a California judge could really give two what's about your Wyoming entity.
Yeah, and like the confusion of charging orders. And so, like to pick it back up, like that asset is in California. That's where that lawsuit is going to come through, not Wyoming. Wyoming law is not going to transfer to California or any other state that's not in Wyoming. So it's going to be that state laws that are going to be applied. Like you don't just take Wyoming tort and damage laws with you to other states. So for assets, that are real estate, for example, we recommend that you just create and use, the LLC in the states where that real estate is located in, because you're not going to, gain anything by using another state. You're just doubling your maintenance cost. And now you also have to maintain the LLC in 2 states. So just keep it simple. And then when we talk about, like legal versus practical authority, Legal authority is what you think would happen if everybody followed the law per the letter of the law and the statutes. That's never happens. That's not how things happen in court. Practical authority is what happens in practical world, what happens actually in court. And what that actually is a judge has a secret power to do whatever a judge wants, whenever a judge wants, and we see it all the time. It's called, I think you're on mute, Josh.
Oh, Josh, you're muted.
Sorry. That's my shock face, by the way. I cannot
another form of asset protection. Just stay silent.
Like, yeah. There's some
so,
people that would actually work for.
Yeah, but there's superpowers called the court of equity. And so a judge has very broad powers to reach your assets. They can seize them, place liens on them, garnish them, foreclose on them, order sheriff sales. And the problem is judges do these things all the time without legal authority to do this. And so by exercising their practical authority or their superpower, the court of equity, what asset protection does is levels that playing field. And judges do these things even when it's in direct contradiction to, like the established statutes and case law.
Gotcha. So, I mean, they'll basically go break the standard just because they think that that's the right thing to do to make it equitable for the current case.
Correct. It's just they want to put parties in whole, and they have the ability to legally through what's called the court of equity. And even if it's contradictory to established case law, a judge can just say, hey, I'm going to equalize the damages.
Okay. So, LLCs have that inside-outside liability. We kind of talked about that, whereas, someone can get sued through the LLC and then try and go after your personal assets. An LLC is basically a container where you're trying to contain those assets. You're trying to contain that liability, right? Limited liability.
Yeah, and it's limited. Like it's in the word.
Yeah.
Limited. Like they don't have the ball on there. And like I'll break it down, a little bit more on why it's also a disregarded entity depending on how you set it up, but you want it to be that way depending on how you layer it. But by layering, what you're doing, layering, is you're allowing your systems to be more flexible.
Okay.
So like for example, I'm from Lake Tahoe. Like we talked about that in the first episode. We get lots of snow there. We also learn how to dress in layers. The first layer is going to be a base layer. It's generally made of merino wool. It's going to sit on your skin. And then you want a mid layer, which is usually a little thicker. It's going to be like synthetic or wool. And then you want an outer shell waterproof layer. And this is going to keep you nice and dry and warm when the weather gets really cold and bad. But by layering, you're now, like I said, more flexible. And when it gets hot, and you're skiing, you can take the outer layer off or the inner layer off, or you can take the middle layer off. You can adjust and make yourself more comfortable. The same thing applies with your asset protection system that you set up. Like the base layer is going to be your LLC, and it's going to be holding, for example, your real estate. Your mid layer is your holding or operating company, like your management company. And in this mid layer is where you actually do want to use one of those states, that has really good protection around them, charging order protections that we talked about, Arizona, Nevada, Wyoming, Delaware. This mid layer protection should be what's called a multi-member entity. Whereas a base layer, like your entry level, your foundational LLC, it can be a single member LLC, because at that base layer entry, point, that single member LLC gets disregarded for tax purposes, but they also though can get disregarded for asset protection purposes, which isn't good. But you want it disregarded for tax purposes because when a client comes to me with 15 pieces of real estate and with 15 LLCs, I don't want to have that client have a CPA mess and have their CPA hate them and have to file 15 tax returns. It just gets expensive. So by making those base layer LLCs single member LLCs, it helps with tax filings when we add that mid layer, like asset management company or limited partnership, because all the K1s will flow directly through the management company.
Gotcha.
But the problem generally is that most clients come to me with 15 LLCs and they're all single member LLCs. And even worse, they're all in the client's personal name as the member because that's how their CPAs decided to set them up for them, because they're not setting them up for asset protection purposes.
They're setting them up for tax purposes, right?
Yeah. And so now we have a problem because the courts have a tendency to go to what you were talking about, Josh, a long-winded way around to answer your question, a tendency to disregard these single member LLCs that are, like held in, your individual name, like in California. A single member LLC held in your personal name is basically worthless, from an asset protection standpoint. So it really comes down to, like, how do you use them all together? What you want a single member LLC that's holding your real estate to be held and then owned by a multi-member partnership, like in Arizona Limited Partnership. What you're now doing is layering your protection. And then we also took away a legal argument. We just solved that single member piercing of the corporate veil issue. And now we just added a jurisdictional benefit of charging orders. And so that's the first two layers of protection and how they, work up and layer up. And then it works best when you add that outer shell, outer weather layer, the bridge trust or asset protection trust.
So let's hone in on that outer layer real quick. You mentioned a bridge trust and other assets. So can you explain the bridge trust and basically how that operates, or maybe give us a story of one that was actually tested that you were involved in?
Yeah. So the final layer, so it's going to go through what's called jurisdiction, and so the final layer is your true full bad weather outer shell layer. Where it's cold and snowing. You're creating an asset protection trust. And more importantly, when we create these trusts, it's picking the proper jurisdiction to set the trust up in. That's the big guns. And it all just depends on the client's needs. What jurisdiction means is that, and why it's so important is that the laws and rules that govern you and business entities and lawsuits, they're going to be different from one state to another, one country to another. So the US to the Cook Islands or Nevada to California. And you really have two options. You can create asset protection trusts domestically in the US, or you can set them up offshores in other countries like the Cook Islands or Belize. I prefer the power of going offshore, but only when it's needed because it just gives the best home court advantage to clients. It's called the power of statutory non-recognition. And what this means—
say that one more time. What's it called again?
Statutory non-recognition. What that means is that your U.S. judgment is completely worthless in the Cook Islands, where they would have to come and collect from you on.
The middle finger of jurisdiction, right?
I was going to say the same way that the California judge could give a crap about your Wyoming entity, the Cook Islands could give a crap about your
California judge.
California.
Yeah, it's the gold pound sand,
Yeah.
And so what the strength of this is the statute of limitations is only 1 year there. So they have to sue you, if they even know they have to sue you there, within 1 year. Most of the time they won't even recognize that in time. They have to prove their case by the murder standard, the highest legal standard in the world, beyond a reasonable doubt. The plaintiff has to front all the court costs and fly in a judge from New Zealand. And if they lose, they pay. And if you're trying to prove a case beyond a reasonable doubt in civil law, most likely you're going to lose. And they can't there's no contingency lawyers allowed there. You can't take your U.S. lawyers there. They have to fly in a judge from New Zealand there. I mean, there's just so many statutory hurdles that are virtually impossible for your average creditor to jump through. And so being purely foreign, just a purely foreign asset protection trust, 5 out of 5 stars. It's very effective. And has been around since the early 80s. So it's over 40 years of just golden case law supporting it. That's why it's the Golden Globe standard still. However, not everybody needs that level of protection. For most, it's overkill. And honestly, a purely foreign asset protection trust is just a hard pill for most clients to swallow because they're so expensive. So what we see are people who don't want to deal with, the costs and the extra hurdles. They're just settling for a purely domestic U.S.-based asset protection trust. And, they'll be less expensive with cost and maintenance fees, but they're going to fail on effectiveness, which from an asset protective standpoint, that's not good because I want them to be at work when they're challenged in courts. And so we're seeing a pattern of these domestic asset protection trusts being pierced in court now. Most recently in Montana, with a real estate investor who used an Alaska trust, they just didn't recognize the trust at all because that investor wasn't a resident of Alaska. Also, we have In re Hubbard, Dale versus Dale, Tony versus Wacker, and then a really important California case, Hilker versus Steelman, 2012, which was a California resident using a Nevada asset protection trust, and the court's just saying, hey, we don't care that you used a Nevada asset protection trust. You're not a resident of Nevada. And so we don't recognize the trust in California, so we're not recognizing it. That gives access to all the assets in the trust. How effective was that? It wasn't.
Which of course I've read all those court cases, because I love reading all those court cases, right? And I'm sure the average person has read all the intricacies of those court cases as well.
and Brian, just to be clear, I want to make this point. Like we've had the conversation multiple times offline. Is the goal of a lot of these trusts and structures is to get people to the negotiating table, right? At the end of the day, when you file a lawsuit, I want everybody all of our listeners to understand this. Nobody wins, right? I mean, in the grand scheme of like, it's expensive no matter what, right? There's no like, oh, hey, I get all the money and you get none. And I mean, the attorneys make money. It's expensive. It's time consuming. It can drag out for years. It takes a toll on you personally and your physical health and on your mental health.
It's in both parties' best interest to settle cases as fast as possible. The posturing of it and leverage comes into play. That's where different levels of asset protection will force a settlement in one person's favor or another. An LLC, base layer, I can pierce that very easy. Anybody can. You can come out of law school and make a piercing the corporate veil argument nowadays, and most likely it's going to get pierced. And that's not good, but they're needed. They're entry level. It gets the asset out of your name. Very strong asset protection, like a bridge trust, which we'll break down, next, or a foreign asset protection trust. I'm going to make that case go away, because even if you got a $50 million lawsuit judgment against me, how are you going to collect on it? Right. And businesses are profit driven and law firms are profit driven. I have to look at how collectible this person is. So when we get into these level of foreign asset protection trust and bridge trust, we don't hide the ball that we have. It's like, hey, we have this and we have a foreign clause in this. The assets are going to transfer over to the Cook Islands. Go away, or we'll give you a penny on the dollar. Pick whichever one you want.
Pick your choice.
And before we dive into the bridge trust, there's another thing that I think we need to make very clear, which I think is something that's kind of a misconception, is there are a lot of people that are like, why would I need asset protection? I go to church. I take my neighbor's trash can in for them. I'm a super nice guy. I'm not nefarious. And there's this thing that like, well, asset protection is for people who want to do nefarious things. Could you give us a story of someone who living a completely what they think is regular, safe life, and all of a sudden found themselves in, kind of a nasty lawsuit?
Well, it's just nature of business. Like, for example, you can have as an investment property an apartment, like 6 units. We'll just say like make a 10-unit apartment complex. And next thing you know, you have mold issue, $5 million mold issue. Maybe that mold issue then got a medical issue with one of the kids. Kid died. Now you're staring down a massively multi-tiered $1 million lawsuit. You're going to basically go bankrupt unless you do something to protect yourself, to then say, hey, it's not like we don't want you to, pay, whatever a reasonable judgment, but you also are investing for your legacy and your livelihood and your retirement. So it's, how do we level the playing field from losing completely everything? So you can be going to church, but you're still investing. You can be going to church and have a business. You can have, be going to church and be a doctor who nicked an artery. Like
happens, right?
Life happens. It's never really the things that we're protecting ourselves from that's intended. Like, I didn't get in my car and intend to get in an accident, but I have insurance to cover myself just in case.
Right.
Same thing for asset protection. Like, I know that my insurance won't be there for the big things. I don't want to lose everything. So how do I then scale up? And then that's what asset protection is. It's not about hiding assets. Hiding assets, is illegal. We don't hide assets. Like, part of the scams of people using like, oh, I'm going to go hide this. I'm going to go tax avoidance. No, all asset protection is tax neutral. It has to be. Otherwise, it's going to be fraudulent. You got to pay your taxes, pay your capital gains, work with guys like you to decrease that amount legally, create the protection systems in advance before you need it, so that you keep more of you have.
Absolutely. Yep. Yeah. No, those are all really great points. I just, people always look at things, linear, right? Like cause and effect.
Yeah.
But there's a lot of stuff in the middle. The example I like to use is, were you texting? Have you ever driven a car and texted while you're driving?
Yeah.
The answer is always yes. And that is literally, if you get in a car accident and you texted and driving, the insurance company is going to pay diddly squat out because you were doing something totally illegal.
Well, there's another thing with insurance, like it's called intentional acts. Insurance don't cover you for intentional acts. What's the argument in a lawsuit all of a sudden when it gets made is it's going to be based on fraud and intentional acts. And it can be as simple as an email being sent, and that judge is going to look at an email. That's a correspondence. You intended to send that correspondence. Now that whole law firm is based around an intentional act, whether it was or wasn't. The insurance legal team is going to say, thanks, we're not covering you now because we don't cover you for fraud and intentional acts, whether it is or isn't. If you don't agree with us, sue us.
Right.
That's the legal defense and tactic that your insurance companies make in court to not pay.
Yeah. So since we had talked about at the beginning of the episode, right, that we were going to dive into the insurance part of it.
Yeah.
So let's kind of talk about how does insurance fit as part of that layered asset protection model, right? Because it is a component of it, correct?
It is a component. It's a base level component. If you're going to go into business or own anything, you have to have insurance. You don't have to. You should.
Right.
It's a first layer to where maybe my insurance will cover me for that, or at least provide the capital to hire a firm and help represent me. The next layer, LLC, and you just layer yourself up. But to simply and blindly think that I'm going to rely purely on my insurance or even an umbrella policy to cover me when something really bad happens is just naive, because it's not going to happen. Because you're never going to get around intentional act defenses, and that's the very first thing that in large cases are going to be added into is a fraud and intentional acts defenses. And then the other big thing, before I guess like we jump into like the bridge trust, I get a misconception of like, what are we protecting? Gross or net value? And like I've had a doctor call in and say like, oh hey, I don't have much liquidity, but he had like $10 million worth of equity tied up in the businesses, and he didn't think because it was tied up in investment properties that it needed to be protected and that people couldn't get to it. And so I think like before we go into the big guns, it's like let's just clear up the distinction of this.
Right. Yeah.
So I don't know if you guys have heard of this saying, but it's a pretty good saying. Gross is vanity, net is sanity, and cash is king.
I like that. Record that.
Record.
Yeah.
You want me to say that
You
again?
said record. Okay, when you said record, I had a slight panic attack that like one of my systems wasn't recording. I was like, woo. Okay.
We'll attribute that to Brian Bradley, BTB Legal.
Yeah, so gross is vanity, net is sanity, and cash is king. And what this saying means is that, for both businesses and in real estate, your gross income is what's perceived you to make you, a big guy, big and successful. So let's say you're at a party, a cocktail party, and an investor tells you, yeah, I gross $100 million a year, with a 1% margin. This guy has to be a big guy, right? Like really successful? Well, maybe not. The next question is, okay, how much do you net out of that? Oh, you only net 4% out of that, so only 4 million. All right, that's not terrible, right? Like who wouldn't want 4 million a year net? It's pretty good. But in reality, cash is king. So this leads to the next question. What's your cash flow? Well, let's just say this person's cash flow negative and they're bleeding money. Okay, so now this turned into a completely different story, right? Like gross income, this is just shows like gross income is just vanity. Is this big shot $100 million a year business investor, really that big? No. When it comes to real estate, the same thing applies. You can have a $25 million real estate portfolio, but let's say only, 20 million of that's mortgaged. So now you only have 5 million net, and if you're cash flow negative, you're bleeding. So from an asset protection standpoint, neither of these investors are actually attractive targets to where if I'm suing these people and it's a large lawsuit, there's not much that I'm going to be able to get out of that. They're not attractive because their net's only 4 million and 5 million, and both are cash flow negative. And so anybody coming to attack them are going to have to take care of the banks first before they get into a position where they can take anything. And that's just because whoever comes in to attach a lien is going to be in a second position behind the banks. So with the banks in that primary position, it's very unlikely to think that a judgment creditor is ever going to get anything out of them. So in the context of asset protection, it's a very important concept to understand that, we're only protecting net. Like what can someone actually get from you? Your cash in your bank account, your equity. Like we can protect shares of ownership of LLC. Like not of business entities and corporations. So I think that's a really important point to clear up.
No, that's really really great stuff. I mean, people always convolute their layers and what they're trying to do and what they're trying to what they're trying to solve, and they usually go about it the wrong way, or they're solving the wrong problem a lot of times. Yeah. So, or we get the standard, oh, hey, I have insurance, so I'm fine. And that's just not, I've proven time and time again, that's not the right answer either. It's part of the solution. It's not the solution.
No, and like I said, it's just layers. It's just part of the layers. And then, like the final layer, is that, that bridge trust, which then owns that limited partnership. So when you hit about that $1 million net worth mark, is when we have this conversation. And you'd be surprised, generally it's around 500,000, and I like the client's 500,000 net to $1.2 million net, because it's taken most of these people so long to build that amount of wealth. One lawsuit is going to completely wipe them out, and they're never going to recover.
Gone. Yeah.
If you're around what is it, like the big hurdle, like what do they say, like 2.5 million net, is like that big leap. You can take a glancing blow and it may not knock you out, but it's going to hurt and it's going to take you time to recover. But you don't want to lose a lot
Right.
more time to recover. It's just not going. You may not lose your house.
Yeah, I think some industry on the insurance side, just to add to your point, is why do you think $1 million umbrella policies are expensive, $5 million are cheaper, and a $10 million gets cheaper? Because they're going to fight that $10 million lawsuit all day long. They already have the insurance company already has 5 legal teams on retainer that are going to fight that all day long. So they're not going to go just write that check, right?
Yeah.
And so that less than that $500,000 lawsuit, they're probably going to settle that out of court as quickly as possible and make it go away. That $10 million lawsuit, they're going to fight that tooth and nail for. They want to stretch that thing out for as long as possible.
No, exactly. And you know what? And strong asset protection systems literally just say, go away, you'll get nothing. And we'll go over the power of it now. And like I said, I like the foreign aspect of asset protection. I don't think you need to be purely foreign. And so
Gotcha.
It kind of goes to okay, we know the strength of foreign, we know the weakness of domestic, we know only 16 states have these self-settled spendthrift legislations. How do I combine the best of them? How do I combine domestic and foreign together and kind of get this cool hybrid best of both worlds situations? And that's called a bridge trust. And so, all asset protection trusts, they're irrevocable, tax neutral grantor trusts. And why you want your trust to be irrevocable, is that if you're ever challenged and in front of a judge and the judge says, hey, Mark, hey, Josh, I see you have assets. We think you have control. And the judge tells you to bring those assets back to collect on. You don't have the power at that point to do it. And so they're not going to be able to hold you in civil contempt. And this has been through case law, like the Grant case. If you can tell your trustee, your offshore trustee, hey, bring that asset back. And he says, no, this is under duress. We're not doing it. You tried. It's not your fault. They said no.
Right.
So that's the power of irrevocability. And then why you want a grantor trust is that it allows you, the creator of the trust, to retain some powers and to invest how you want. And this makes it easy to continue investing and getting loans, and like all asset protection trusts, like I said, they're self-settled spendthrift trusts, meaning they're created by you for yourself as your own beneficiary. And then the win-win is, for the purpose of IRS reporting and disclosures, your bridge trust, even though it's an actual foreign asset protection trust, it's actually classified from day one as a foreign asset protection trust. It's registered offshore in the Cook Islands from day one, which a lot of people actually don't do, which is not good. You should register it immediately day one as a foreign asset protection trust. But the bridge trust is classified as a domestic trust by the IRS because it meets a 2-part test called the court test and the control test. And so all that we really do, if you're being challenged and you have a big lawsuit and you call me and say, hey, we have to trigger it, and I agree, we have to trigger the trust, all we're doing is dropping the IRS compliance, and it's no longer going to be classified as a domestic trust. It's now just purely foreign.
Gotcha.
And so how all this kind of works together is the first layer is your base layer, your insurance and your single member disregarded LLC. And these LLCs will hold your real estate and other assets that can hurt somebody, or it has a key, it can go boom, like boats and planes. The next layer is your multi-member asset management limited partnership. That's going to act as your holding company, your operating company, and it's going to hold the bulk of all your assets. And so it's going to own those LLCs, and it's going to hold your cash and stocks, bonds, receivables, syndication shares, whatever.
Sure.
The final layer is your outer layer, which is the asset protection bridge trust, and it's going to be the minority limited partner, and it's going to be, the mid-layer limited partnership. This is the non-controlling interest, but it's the ownership interest. So that bridge trust is actually going to be the owner of that management company. And then that separates ownership from use and enjoyment. And you're also the beneficiary and trustee of that bridge trust. And then either you die and your assets get distributed, many, many decades from now per your living trust, or there's a crisis like a lawsuit, the bridge trust is triggered, the assets cross the bridge through the migration policy, and now you have the power of statutory non-recognition in your back pocket.
Gotcha.
So real quick, because you said something that I know, I know is very important to point out, and I think it's a turnoff for a lot of people. So these are irrevocable trusts. Now, when someone sets up an irrevocable trust, are they then are they completely out of control and can never gain control of those assets again?
Good question. So there's different types of irrevocable trusts. Like if you have an irrevocable, living trust, that's different than an irrevocable asset protection grantor trust. They're completely different types of trusts. Because it's a grantor trust, you're still going to be able to invest how you want, especially while it's purely domestic. So there's no limitation to that. And so it's just, and you got to look at what type of trust am I creating and go from there. So just realize, like, the big misconception is everybody just lumps it all into one general category. But remember, there's lots of different types of trust and different categories of things.
There are so many types of trusts. Yes.
So many. Yeah.
Like, so many. And also, because this also, Josh and I know this only by virtue of having conversations with you previously. So could you share with our guests why that's so important that the bridge trust has the foreign asset protection trust registered on day one, and how that kind of ties into that fraudulent conveyance?
Great. Good question. So, it comes down to a conveyance happens when you change ownership, of an asset. So at the point, if and when, you ever would have to cross that bridge, and most never do, there's not a change of ownership because the bridge trust already owns the assets from its creation. It's just one trust. It's a foreign asset protection trust. It just maintains domestic compliance. So we're not actually transferring it into another trust. It's just one trust. We're just dropping the domestic compliance. So that trust already owns it from day one. And because it's already registered from day one in the Cook Islands, there can't be an argument saying, well, they didn't go and registered in the Cook Islands until after they had notice of a lawsuit or after they were served. This was done a long time ago when it was created, when everything was peaceful and calm. And then, like wine, it ages and it matures and gets stronger and stronger and stronger.
Gotcha. Yep.
And if you think that you're going to find yourself in a lawsuit and just give all your assets away and call it good, like, wow, you have another thing coming. That is not how that works.
Well, and some people are like, oh, well, I'd rather just pay, whatever, is a fair share. Then that's fine. Like, there's no judgment on that. That's fine. But the people who want to protect, themselves or find asset protection to be, a necessary part of their life to give them, peace of mind, then it's for them.
Absolutely. Yeah. Brian, quick question. We should have done this at the beginning of the episode, but we get this question all the time because people hear the word trust and they think it's like, oh, I have a trust. I have all my all my trustee trusts. That's not a thing, right? Your revocable living trust, right? The one that everybody should have, especially if you own a house and have some kids and that sort of stuff. It's where your stuff goes should you pass. Does that provide any asset protection while you're alive?
No, it does. And it doesn't provide any asset protection in general because they're not designed to. It's not what they're there for. They're literally there, you said it, to avoid probate, help with death taxes, and and give your medical directives and your financial directives. Like that's what they're designed for.
Sure.
There's an asset protection trust is completely different, and the two will work together.
Absolutely.
Like you need to have a revocable living trust to name those things. I wouldn't put your house, if you wanted asset protection, you put it in the bridge trust. Now it's protected. The revocable living trust would just be named in the asset protection trust, and then that way, whatever your directives are or who your named beneficiaries are, the assets get dispersed for that.
Right.
But the revocable living trust, it's just there. It's it's a way to do things 40 years ago, before we had massive litigation issues, out of control medical costs, and tons of divorces. So the tax part of it is irrelevant now because the death tax level got raised to I think per mayor 20 some odd million.
Like 11.6 per person. So a lot of it's
like 22.2 million. So right now that's less than 0.1% of most people. So that's not necessary. Not that you shouldn't have one, you should have it. But what you're doing is identifying your beneficiaries, and avoiding probate, because you just don't want to judge in a court and state laws dictating who gets what, when, where, and how. You want to say that.
Yeah, and there's
And
some help in
having
there.
a public record for everybody too.
Yeah. And there's some good help in there if you have, split families or somebody passes and you want to make sure assets go to the right spot. You can, there's some neat designs you can do in there, special needs part of it and all that kind of stuff. They're very important. They just don't provide the asset protection everybody thinks they do.
Correct. They don't provide the protection. So you just marry the two together.
Sure, absolutely. Okay, good. So for all of our listeners, your revocable living trust, your RLT, does not provide any asset protection for you while you're alive and or dead. That's just not what they're designed to do. So there you go.
Even though Mark asked like some success stories, like I can give you some success stories, but then I can also I think that going through like how it gets triggered goes into these success stories is a good example.
Sure.
And so over the decades of using these trusts, and for example, you have over 40 years of solid case law on foreign asset protection trusts. Once the bridge trust gets triggered, remember, you have over 40 years of foreign asset protection trust law, to fall back on. That's why it's still the global gold standard. But what happens is, if I ever have to trigger, the trust and cross the bridge, is a client's going to call. They're going to say hey, I got to trigger the trust. We got to cross the bridge. I'm being sued, and they're panicking. The first thing is calm them down. 9 out of 10 times we don't need to trigger it. This is what our life is about. We're not going to panic. You're panicking because it's new to you. Kind of like a real estate flipper walking into a dive. They're going to see something different than a person doing a flip for the first time.
Right. Yeah.
The profit line, you're going to see a mess that you just want to go vomit on and run out of the building as quick as possible.
Yeah.
Well, our first job is to calm you down and say it's not as bad as you think. Now let's look at the other 10% of cases where we agree, it's time to pull the trigger. The process is going to go like this. First we declare an event of duress, and it's done through the trust protector. So us, the law firm, it'd be me or my affiliate, Doug, not you, the client. So it's generally, like I said, us, the trust protectors. And so we would draft an actual document that literally says, declaration of event of duress. The client then signs that and acknowledges it. Now the client isn't actually approving it. They're just acknowledging that us, the trust protectors, are declaring it and making the decision. And then after the client signs and acknowledges it, then we, the trust protectors, sign it, and then it gets sent off to the offshore special successor trustee, who's already got your trust, and they went over it. We let them know what's going on, and then this causes the offshore trustee to become the full trustee. And we draw the client as named trustee. The offshore trustee, steps into the place like we talked about before. That way, a court can't hold you in civil contempt and force you to bring assets back. That's the strength of this. The next step is to look at what needs to be done from an asset protection standpoint. Do we need to move assets? But I'm going to tell you point blank, if the situation is serious enough, that I actually have to trigger the trust, then we need to move the assets. There's literally no point to trigger the trust and then not move the asset.
Gotcha. Yeah.
And this is where a lot of people and other firms go wrong, is even though, these clients, even if they just went purely foreign and just created a pure foreign asset protection trust from the beginning, a lot of times they just connect it to another domestic entity, like that domestic LLC in the US, and then they have all their assets still domestically, and they never actually took advantage of the offshore component that created it.
Right.
So now all the assets are going to be tied up again. And so it's no, if you're pulling the trigger and you're, going offshore, you're going offshore, until the lawsuit goes away. And now, so the trust gets triggered, and the offshore trustee has to now look at the assets that are going to be moved. So if we're going to say it's $2 million in a brokerage account, okay, the next question is, what are we going to do with that? We got to put it in something. It has to go somewhere, right? It's just not going to be in there. So the trustee needs to then go and open up a new bank account, generally in a safe jurisdiction. It's going to be like Switzerland, Liechtenstein, Luxembourg, or even Australia. Any jurisdiction where they don't recognize judgments, of other jurisdictions.
Right.
This step's going to take a little bit of time. Triggering the trust happens quickly, within a few days. Getting the offshore account set up is going to take, a week or two. But lawsuits take years, generally.
Right.
So you got plenty of time, to go through the process. And so if we're talking about real estate, we need to get the equity out of the property. So we're generally going to pull about 80% of the equity out of the property with a lender. We're not going to pull it all out. We want optics to look good. Generally, our recommendation is just sell it. Like, it's the cleanest way to do it. And at that time, we just want the equity. We don't care about the property or the assets. Like, if we're pulling the trigger to preserve your lifestyle and your assets. So but the equity, let's say it's like $5 million, it has to go somewhere. If it goes into U.S. bank, then you just made it really easy for a judgment creditor to collect on and get access to that cash. So you did all this work for nothing. So it's just this, you really didn't protect anything. So this is why, if you decide to trigger the trust and, strip the equity out, you need to then have the offshore bank account, and, that's in a safe place and jurisdiction to actually do it in.
Gotcha.
And then, like some success stories, like we had a $34 million malpractice suit that settled for under $1 million, a $5 million judgment that settled for under $200,000, a $32 million bank loan dispute settled for, $2.5 million, a doctor's medical malpractice judgment for over $3 million, that's completely went away. It's a really strong system.
Perfect.
Now, we could talk about asset protection for hours because it can get very complex. One thing I do want to do real quick, before we wrap up the episode is like, there's probably a lot of people who hear this and think this is super complex. It's probably not for me. Like, what should people, if someone has a checklist to see if they should be exploring asset protection, what would that checklist look like?
I would say, one, what's your profession? Where's your liability coming from that? Two, what is your assets that you're investing in? Like if you're a business owner, then what is what do I have to lose from a lawsuit from there? Do I have corporate shares in stocks, or how do I own that entity? The next is, how do I have real estate, heavily litigated area? Lots of things can happen from there. How much do I have? So as you look at it, no matter what level you're at, just layer it up. Insurance, LLC. It has to be held in something. That's the foundation, even of a bridge trust, LLCs. Then as you're growing and you kind of hit that 250, 500 net worth mark, asset management company. Have that management company, simplify your life, get all those K1 flowing through one entity, layer up your protection. And then when you hit that $1 million net worth mark, come back in with the bridge trust or a foreign asset protection trust. But I wouldn't recommend going purely foreign unless you're actually, already going to be sued.
Gotcha. Yeah, that makes sense. Very cool. Awesome. Mark, quick speed round to end up this episode.
Yes. Okay. So, well, that last question was probably a good speed round question, but I kind of want to piggyback off of that. If someone's listening right now, what's probably, what's probably the most common thing you see on the real estate front that people find themselves in a lawsuit in?
Oh man, it can be a lot of things. I couldn't answer that. I mean, you can go everything from like mold issues to fires. You get a lot parties drinking and driving, and someone T-boning somebody and getting, killing, vehicular manslaughter. But a lot of contract disputes, deals falling through if you're a real estate syndicator and you're the general partner on that. Like, your name's on everything, so those deals can generally fall apart. Now you're liable for everybody. But I mean, there's just so many people that you can get sued through on the real estate front.
Yeah. So, and then, real quick, probably another good speed round question is, how late is too late? Because I know people struggle with that too.
How late is too late?
As far as like, hey, I need asset protection.
Oh, that,
dead already.
It's like, if I don't know you, like, I'm generally not going to, pick up the phone, after 6, like, you'll go to my voicemail and I'll get a message. But then if I really, like, depending on where you are in the country and the world, like, it might just, I have to talk to you at 9 or 10 at night. Like, I had a client in Japan, that called, and like, we just had to, because of where the time zone sets up, but like, if I don't know you and like, you're not a client, don't think I'm going to pick up your phone past this.
And as we talked about in our last episode, you are a family man. You do have a family, so clients are important. Your 2 princesses, a little bit more important.
Hey, Brian, real quick, I know there's a lot, especially in the real estate world, because we work with some of the entrepreneurs, self-made people or the do-it-yourselfers. Mm-hmm. Is this really something you can do yourself, or you would recommend doing yourself, or is that usually just you're probably going to make it worse rather than better?
You wouldn't make anything. You want to make it'd be horrible. Like, don't be your own CPA, don't be your own doctor, don't be your own lawyer. Lawyers don't be your own lawyers. Doctors aren't their own doctors. Like, there's a reason. Like, it just doesn't.
Right.
There's way too. This is all devil in the detail stuff, And one detail that's missing, for example, like I would gut you in court because of that one detail that's missing.
Wow, that's a brutal statement. I will gut you in court.
That's what we look for, and just one little hiccup will make the whole system that you created fall down. So you can be penny wise, dollar stupid and do it cheap and self-create it. I don't care what happens when things are good. Like, I want something that's going to hold up or put you in the best position of strength and leverage at a negotiating table that's actually going to work. If you did it yourself, you're not negotiating from a power of strength.
Right.
Yeah. Yep. Which is always baffling. Like when people are like, "Oh, I'm not changing my own brakes or doing my own oil. I'm not going to do that. I'm going to pay a mechanic to do that." And then we have met some people, who are wanting asset protection. And they're like, "Yeah, I think I can do this myself." It's like,
yeah, you're
best of luck. Woo!
Going online and creating their own LLCs. Well, that's great if you only care about taxes, but if you care about your, asset protection, how did you create that system? Like, are you the single managing member? Or are you like, how did you name yourself? How did you title yourself? How are you getting paid? Like, these are the things also that, how are you funding it? Like, these are all the things like devil in the detail that we'll pierce that real fast.
Yeah.
Yep. Absolutely.
I did not know is not acceptable in court.
Yep. I will gut you in court.
And I won't get sued because I'm asset protected.
Well, hey, that was all good stuff, Mark. I think we'll end it up right there. Brian, thank you so much for being here and letting our listeners know this important topic of asset protection. I mean, this is a huge deal in the current atmosphere for the last couple of decades. It's important stuff.
No, and especially as we get more, globally unstable and economic fear and geopolitical stuff going around. Like, just you got to protect what you have, and you're investing. It's not a matter of what you got. What do you keep? You want to be a good investor. You want to keep more of it, and that way you can grow it more. And that's where guys like you come in. Like, I protect your stuff. Guys like you, help you with your mitigating your tax stuff. So you kind of have to, protect it, has to go somewhere. Want to keep it, like I like what your guy said, protection, tax efficiency, and then invest. If you mess up with that order, like, a lot of bad things can happen.
Yeah, like we talked about, it's way easier to keep money than it is to remake it again. It really is. Absolutely.
Yeah, and it's really easy to lose money by doing dumb things and not protecting yourself.
That's right. Yeah. Yeah. Well, awesome. Well, I can end it there. So make sure you check us out, wealthpreservationpodcast.com. Brian, how can they get a hold of you?
Yeah, my website, www.btblegal.com, and tons of educational videos on asset protection and different layers and how to tier it up, and how to be from a newbie all the way to the big fat whale. Like, there's something for everybody. And email me, Brian, BRIN @btblegal.com. LinkedIn, I love being on social media on there and answering people's questions. And we do free consultations just because I want people to get access to information. So, yeah.
Awesome. Well, hey, just remember, anything that's said here should not be taken as tax, legal, financial advice. If you do have an issue or you have questions, get good help. Pay somebody to get good advice. Pay your advisor. Pay your CPA.
We might know someone who can help you.
Brian Bradley. Right there. Give him a call. No, I really do. Get good advice before you make any decisions. That's really going to go a long way. It'll be literally sometimes almost worth its weight in gold. So thank you so much, everybody. Thanks for joining us. Brian, thanks again.
Yeah, thanks, guys.
Awesome. This is Josh and Mark signing off. Thanks, guys.